Have a quorum. It's 7:02. We will call the meeting to order. Welcome back. Pleasure to see everyone. Much appreciated after a long summer break. So we've got a rather full agenda in front of us. So first for the we've got the public engagement, and that would be anyone from the public who wishes to speak. Bill, Tom, Brian. Okay. So with that, we've got the minutes themselves from June 5th. So those were sent out to the members for review. First, we'll take a motion to approve the minutes and then have further discussion as may be necessary for that. Do we have a motion to approve the minutes, Catherine? Looking to you as the drafter.
Sure. I move to approve the minutes.
Okay, so there's a motion to move the minutes as presented. Is there a second?
Second.
And seconds, very quickly. Okay, with that, overall, I will give just a quick premise. Thought the minutes were very well detailed and appreciate you taking them and getting them over to satisfy a very quick request that we did have for those minutes, so much appreciated. Anyone have feedback or thoughts on the minutes of the June 5th meeting? Saying none, there's a motion that's been made and seconded to approve the minutes as presented. Without, as per customs and as required by the open meeting law, with a remote meeting, we will go as a roll call vote, as all votes will be this evening. I'll do it in the order in which you appear on my screen. So, Catherine, you get the privilege of being first on the screen for that.
Yes.
Okay, Joe.
Am I mute?
And now I can hear you.
Yes.
Kevin?
Yes.
Lucy?
Yes.
Anne?
Yes.
And I vote in the affirmative, so the minutes are approved unanimously. We've already gotten through about half the agenda. Well done. Okay, item 4, update on legal counsel. So just a quick bit of background. We were planning and hoping to have a subcommittee or a different body appointed by this one as a subcommittee to this body to do some additional work for the zoning piece. The group is constituted, was unable to have meetings. We found out recently part of the reasons behind that, and why it also is the reason why the agenda for this meeting had to be swapped around, and why we're continuing for the most part with general bylaws instead of zoning. And with that, I'm going to turn the more detailed explanation over to Tom, because you can probably put it into a more accurate terminology than I would.
So you may know that there are a couple of 40B projects pending before the town. One of them involves a developer named Scott Green, and among Mr. Green's development team, is a lawyer named Paul Haverty. Mr. Haverty is a partner of Mark Bobrowski. Mark, by virtue of signing on to be counsel to the town for the purpose of codifying the zoning bylaws, has made himself a municipal employee, quote unquote, within the meaning of the state ethics law. There are restrictions as to what can be done by the partner of a lawyer who is a municipal employee, both under the state ethics law and also under the rules of professional conduct that bind all lawyers. So when, excuse me, it was actually Steve Mayo who caught this, brought it to my attention. And last week, I think it was, I called or emailed Mark Bobrowski and asked, were you aware of this? Because it sounds like it's an issue that we ought to deal with. He apologized. He said he was not aware of it. He and his partner separately got into these two different but potentially somewhat conflicting engagements, and neither knew what the other was doing. So I propose to ask the town council to do whatever has to be done in order to cure the apparent conflict. And there are a number of things you can do. I, for example, have previously represented both the town of Wakefield and the neighboring town of Linfield on matters such as the rail trail when there was no genuine issue between them. But there are some documents you've got to get signed by both sides. So I'm going to recommend to the town council that they vote to do so, and I will prepare, with Mark's help, documents that satisfy both of us. That said, of course, it's not my decision. It's the town council's decision. So we'll see.
So thank you. What I'm hearing from that is that until that issue is resolved, things with Attorney Bobrowski are effectively kind of on hold, just so that the ethics issue can be resolved before he can really resume doing work with us and the town.
Yeah, I mean, to whatever extent there may be a technical violation of either body of law, so far it's been entirely inadvertent and unconscious. But now that his attention has been brought to it, it's really got to be cleaned up before he does any further work.
Excellent. Thank you for the explanation. Any questions on this?
Is there a timeline for resolution or next steps?
Well, I certainly want to talk with Mark about this before the next town council meeting and get before them whatever documents he and I agree they need to sign to cure the problem. I'm not sure just when their next meeting is. I don't think it's until October.
Okay, thanks.
Mm-hmm.
So what I'm taking from that is it's a delay of, at this point, probably another 3 to 6 weeks, potentially.
Not, I shouldn't think it would be 6 weeks, but it's probably about 3.
So our next meeting would also probably be not those agenda items.
Yeah, it really would not be safe for Mark to take any action with this committee until this is cleared up.
So in the meantime, we've got other articles to deal with.
Mm-hmm.
Any other questions, comments, or concerns about that? So I've just learned about all of this over the last week, and as this issue has come up, again, we're getting excellent guidance from Attorney Mullen, and I've got full confidence that the issue will get resolved. And what I've heard is that there's no actual conflict of significance that has occurred, so it shouldn't present a problem, provided that all parties agree that any potential conflict can be waived. It'll be done, and then we'll continue on with both the smaller board meeting and the larger meetings as appropriate. So with that, we've got a bunch of existing bylaws to review, and then a couple of new concepts to discuss as well. So first up is chapter 147. Sidewalk cafes. I'll bring it up on screen here. Excellent. Are you able to see screen with chapter 147 sidewalk cafes?
Yep.
Okay, so these bylaws have been reviewed in between 2016 and 2019, but for our particular mandate, we'll want to just take a look at them again, see if there's any additional changes that should be done. This particular bylaw is relatively new. It was adopted in 2012. So it's at this point, 11 years old, should be looked at. And this is what allows for sidewalk cafes to exist in the town itself. A lot of different components to it. Again, minor changes were made. Some of these where you see it was just in November 5th, 2018, a lot of these had to do with the rename of town council. As we get started, any questions or comments up front on sidewalk cafes? Again, the purpose of this is to allow for sidewalk cafes to be permitted. This does happen and has been happening, especially with COVID. I think this became very helpful for the town to have a way so that the cafes could open. You may see various establishments that use sidewalk space. This allows them to do that. I'm not aware of any of any cafes where they've had the actual permission revoked. Otherwise, it's requesting information on the actual application itself. The implementation of this has changed because of through the COVID years. It used to be that there was not space typically closed for the cafes. Now space is often closed for the cafes themselves. But again, I think this particular bylaw allows for it to happen either way.
Does the application process live anywhere else than in this bylaw?
I'm not sure I quite understand the question. Tom, do you know the answer?
So I don't know whether this, there's an application form that exists online, if that's the question. I don't know.
Yeah, just thinking about like whether the application process needs to be in the bylaw, knowing that like those types of things you may want to have some more flexibility than at the bylaw level. But if there's no like issue that has come up, then I was just curious.
So are you referring to just how specific the application has to be by bylaw?
Yeah.
Tom, do you have any thoughts on that?
So I've never heard of anybody having a problem with this bylaw. There's no applicant has ever complained that it was unduly burdensome.
Yep. Okay.
The only issue that I've heard about actually has to do with section K, specifically A-frame signs being put into the pedestrian zone, that section not being enforced. Because it does have a designated section, statement of what has to be required. And that enforcement, it's not clear who actually is supposed to do that enforcement in the bylaw. And what, as a matter of practical course, it largely has not been enforced by the town. I think in many cases, if people ask or just move the sign, it's not a problem, but it has been a very real issue because it impedes access, particularly for people with disabilities. I'm not sure that in and of itself necessitates a change to it. Tom, do you know who would be responsible for that enforcement?
Yeah, I should think it would be both the police department and the DPW. I'd always tell the DPW, if you see something on town property that doesn't belong there, you have every right to take it off.
Yeah, I think
And of course, the police, enforce our bylaws, unless the bylaw says otherwise.
yeah, they'd still be required to pull a permit with engineering to put anything in the public way, so.
Including a temporary A-frame structure?
They're supposed,
As-
well, I mean, the A-frame structure, I think that's something where we would just tell them to remove it. We've done
Okay.
that in the past. I know our guys do that.
Because that's one piece it is in the bylaw, so that's the reason why I'm mentioning it.
Yeah, the only thing that's a little different is they don't really reference the public rights of way accessibility guidelines. It's more, looks like it's referencing the site ADA guidelines, so that might be something that's needing a tweak, but I can look to add that for the next one. The next meeting.
That would be helpful.
Sure.
And that probably impacts both the clear pedestrian zone and the setbacks.
Yes.
Okay. So we'll look to get guidance on that for the next meeting. For the residentially zoned parcel, this is not something that is zoning specifically. Tom, this one may be for you. Does that mean that it has to be named as a residential zone, or that residential zoning is permitted in that area?
50 feet from a residentially zoned parcel. So as a practical matter, you would never or almost never find occasion to apply this bylaw in a residential district. And this just requires that the cafe be set back at least 50 feet from any residentially zoned parcel.
And what comes to mind is with the increase in mixed use residential, where we're seeing, including downtown on North Ave and so forth, to have a sidewalk cafe, would that be deemed a residentially zoned area? And I'm thinking, as an example, would be like Tano's, if they wanted to expand and have something, because there's literally residences on top of the restaurant.
So the fact that there's residential use within the building doesn't make the parcel residentially zoned. Okay,
So, and that's really the question, is what defines a residentially zoned parcel?
it's either got to be in single residence district, general residence district, or SSR, special single residence.
Okay, should that be defined somewhere?
Well, actually, I think actually it's pretty clear to anybody who does zoning. A residentially zoned parcel is one that is already zoned for one of those 3 residential uses.
And an overlay would not count?
No. This looks to the underlying zoning.
Okay. And I'm asking just because with the way that the construction and zoning has been moving, this is becoming more of an issue with combination type of housing.
Hmm.
So I'm just wondering if there may be clear wording that can be used there. Exit requirements, town council, CIL, not Tom, gets to do the full review of the application. Items for the permit. And lastly, their responsibilities. Any questions on this? So what I've heard so far is we will want to revisit this as it relates to the dimensional componentries. And it might make sense to revisit the language around to define what zoning is permitted versus not, just so that it becomes clear for people who are looking to take advantage of this. If we look at the small business owners who have a lot of these who have a lot of these restaurants, they may not understand that terminology, especially in light of mixed use zoning.
Dan, Joe Pride here. I just read through this quick. Is there anything on signage in there? Because if not, we might want to add something that permits them to just adding signage without going to the building department or the ZBA on that.
So signage is permitted
Was it on there?
in section K. So umbrellas, A-frame signs, portable signs are permitted, but not in the pedestrian zone.
See, that seems weird because it seems most of the time they have to come to the ZBA on signage. So it seems a little unclear that they could put up any signage they want.
Yeah, Dan, I think Joe's onto something. I don't think that this does allow A-frame signs or portable signs. I think it says they are not allowed within the pedestrian zone. Meaning if you've got permission otherwise for one of these signs, you have to keep it out of the pedestrian zone.
But do you need special approval once you get approval to use the space for a sidewalk cafe? Can you use some of that space for signage? Do you need separate approval for the signage itself?
I think you'd have to go through the sign approval process that's in the zoning bylaws.
Yeah, normally they would. I would think so, and it doesn't really say that here, so I don't know if we should add that. So they're not just adding signage and then getting, letters or whatever from the building department saying, hey, you just put up a sign. You weren't supposed to. You have to go through the signing committee and all that, and they said, well, it wasn't in your bylaw that I had to, so I don't know if we should add that or.
I remember a conversation about A-frame signs when I was on the council. And it was very specific, like what kind of A-frame signs were allowed, the size of them. And it was, my memory could very well be wrong, is that it wasn't part of the signage committee. That wasn't, I don't remember at all that those signs had to go before the signage committee, but that might be something we need to clarify, or unless I'm forgetting details.
Yeah. And I'm remembering what Ann was talking about too, I think, and I think it was the town was actually buying A-frame signs and wanted to give them to Main Street merchants to try to create some kind of uniform and visually interesting kind of signage that would go, unlike other signs, onto the sidewalk. Generally, you put something on the sidewalk, and again, I'd tell the DPW, take it away. But this was an attempt to have the town council permit individual merchants to use these things, subject to various requirements such as, you know, don't put it where people are going to trip over it, and anchor it.
You can see those signs. I can think of a few right now that I'm almost positive were part of that, because they're the same sign. It's it's a fairly small easel. It's a chalkboard.
Yeah, and it was not, you're right, you didn't go through zoning to get that approved. One reason is I've always taken the position that zoning doesn't apply to the public way. You know, you can do anything on a public way, any kind of use. You can access a residential use, access an industrial use, a commercial use. Unlike a private way, if a private way goes through a single residence district and leads to an industrial use, you've got a zoning violation. So you can make any use at all of a public way, independent of zoning.
Yeah, but does that mean that anyone in town can just put up a sign like CVS and put it on the public, on the sidewalk then?
No, it means that the custodian of the public way, which is the town council, can grant CVS or anybody else a permit to allow them to do that.
Okay.
Bill was talking about getting a permit to use the public way. And that's because we own the public way.
So by that statement, so something like the A-frame sign, as long as it's not in the clear pedestrian zone, which would be 147.9, it doesn't require further approval if there is granting of a sidewalk cafe.
Yeah, so we might actually want to think about putting something in here whereby a sidewalk cafe has to state whether they're proposing some kind of signage on the public way. And if so, they should get specific. What is it going to be? Where is it going to be? How is it anchored? How do we know it's not going to get, in the way of pedestrians?
Is that something that should be added? And I'm just thinking off the cuff here, added to the bylaw in a way that's relatively flexible so that the town council can change the form as the needs may dictate, so that the bylaw says that there may be a requirement for signage details and restrictions, something along those lines, without getting too detailed in the bylaw, but set the expectation, then the details can be set by the town council as the needs may change and get managed. That I think that would address the issues that Joe is bringing up, Bill's bringing up, and would be consistent with the other program as well. Is that language that would be reasonable to come up with?
Yeah.
Okay. Without having to remove you from the public way. Just want to make clear of that. Okay. Other comments, questions? Otherwise, there's great feedback. This is actually the type of changes and feedback that this committee is charged with doing. So we're actually really excited to see these types of changes. They may seem trivial and minor, but they are to really improve the bylaws. Any other items on this? Moving on. News racks. Bill, you might know the answer to this question. Do you know how many news racks are actually still in town by chance?
I know of one. I think that's all I've seen recently, so I couldn't even venture a guess.
Tom, do you have any idea if it's actually greater than that? I remember when this issue came up about 5 years ago, the people thought there were a lot of news racks. At the time, I think there were two or three. So it wouldn't surprise me if we were down to one news rack.
Yeah.
And we do have more news than that, just to be clear for the public record. We do have more news than that. It just may not necessarily go onto a news rack.
Aren't there 2 to 3 outside the library still?
That's the one I was thinking of.
It's just
You
one?
should this, I thought it was only one.
Oh, maybe it's just one now. I might not have been paying attention.
Or I could just have, it caught my attention that it even existed, so. You know,
So this is carrying on with the sidewalk conversation. This is really about, again, usage of the public way. In this case, it's for the purpose of a news rack. And it's where the news rack is located. Definitions, again, public streets, roadways. They can't be on streets, only in pedestrian areas. I don't think that we've had any problems with news rack installations, but it is an issue in some communities where people and organizations in particular will put up news racks to have inflammatory news. This is an issue in some places. It was an issue of more significance years ago. Otherwise, there's a bunch of locations of where these need to be. I haven't taken a look at the news rack that Bill is recalling to make sure that it's actually following these dimensional changes. Something, Bill, if you want to take a look at some point, might be interesting, just to make sure that it's actually within these components. That's not near a fire hydrant in particular.
yeah, I'm pretty sure it will go there. It's in this there's a wide sidewalk there, so it's like right up against the back of the right of way.
Dan, don't let them take the only news rack left down.
Wonder if there's anything in it. That'd be the better question.
Trash, probably.
Right?
That wouldn't be news. So there shall be a sticker issued by the Department of Public Works. Do we know if those stickers actually even exist?
I haven't seen a sticker or a news rack.
Tom, are you aware? It looks like you may be having some technical difficulties, Tom, or connectivity difficulties.
Dan, do we want to look at the use of will in section 10, subsection 10? Because I don't know. I like in this type of situation, I don't mind may as opposed to will, because it puts a bit of the onus on DPW to monitor news racks, and I think they probably have better things to do. Unless a complaint comes in.
Right.
And Tom, are you able to hear us? Hopefully he will be able to rejoin us in a moment. I think that you may be onto something, and if there is a component, the key to that is if the will requires it to be immediately upon 15 days, or does may make it so that there has to be a process, an additional process to remove it, as opposed to something more specific. If it as a will, it just gives the right to the town to remove it. I'm not sure that it requires that they remove it on day 16, but then they don't need further authorization. Doesn't have to go before the town council or other piece. If it's a may, someone could argue that.
I mean, great point. Yep.
And my speculation is that no one has paid the $5 a day fee. Certainly in the last 5 years, let alone probably even the last 10, 15, or 20. I would imagine that if the news rack were removed, it would almost certainly be abandoned. And it looks like Tom is rejoining. It appears Tom may be having some technical difficulties. The other piece, and again, Bill, you may know more about this, is if the insurance is actually, the insurance requirement is actually enforced.
I mean, again, I would tend to doubt it. I don't, we haven't seen anything for this bylaw, I think, at least since I've been here. So in the last 5
Okay.
years, for sure. Yeah.
And there's supposed to be an annual fee. So,
It looks that way.
and I mentioned that because that would be reason enough for it to be addressed and looked at, because if there's one thing we know that that certain people at town hall like, is they like to get the ancillary fees when they can. I won't mention certain town administrators by name.
I think this is a good thing for Bill to bring back to Joe Conway to see when's the last time we had stickers, when's the last time we might have, I never in my years, 9 years on the council, ever remember a news rack coming before us.
Right.
So maybe it's, Joe in his folks can give us a little more information as to whether or not some of this is necessary or has been done.
Yeah, we can definitely do that. I've been trying to text him as we're on the phone here. So
So that would be helpful. We'll revisit this at the next meeting. We'll try to get some more detail on this. If it turns out that the news rack doesn't exist, then this may become an idle bylaw that just sits there, may not need any additional changes. By the same token, there may also be an opportunity to collect fees if they haven't been collected. Or I'm not sure if there's the ability to go back for prior years, but certainly for current year and so forth, if that has not been collected. Any other feedback, thoughts on this? This brings us over to chapter 154, peace and good order. I think this is also gets to using of the public ways, and as Tom had said, if something is in the public way and is not being good, it can be removed. Okay, so peace and good order, this gets to things that are allowed and not allowed.
So Dan, let me get this right. You can't throw snowballs. Is that what I'm reading? You see that first line?
That is correct.
All right.
On the public street.
No snowball fights. All right.
No snowball fights on the public street, which
it
in a
does
lot of
play-
ways in a lot of ways makes sense, because otherwise you could actually have snowballs thrown at cars and so forth. So this makes that actually an offense.
and no playing in the street either. That's bad as well.
No, my parents told me to play in the street though.
Keep in mind, no dangerous missiles are allowed either.
All right.
That's it.
So no throwing of stones, snowballs, or dangerous missiles. It's very specific to the public street. So if you do wish to throw stones, snowballs, or other things, say around Lake Quantapowhat on the non-street area, that would be permissible. So any snowball fights that are going to happen can happen on the common. That would not be the way that it's worded here to be problematic.
Well noted. Well noted.
Disorderly conduct. So no one shall engage in fighting or other acts of violent or hazardous nature, or make threats of fighting or other violent or hazardous acts in any public parks, common, or place to which the public has access. nor behaving in a loud or boisterous manner so as to annoy anyone else who has public access. In other words, don't be loud, I think is what this is saying in short. If
Well-
there is, this gives the police the authority to have someone discussed and potentially ticket them for disorderly conduct. It would be a local bylaw violation and using standard fines of up to $300.
Yeah, if Tom comes back, I'm curious whether this is duplicative, because there's a disorderly conduct charge.
Which
Yeah,
would be criminal, and this would be
Right.
civil.
Right.
So I think the idea behind this is that this becomes a civil matter, and so the standard for it would be significantly reduced, and would not require someone to have a criminal action that would
Right.
go through the criminal process. But it's a great question to bring up, Tom, if we're able to get him to join. Along those lines, no one is allowed to spy in windows.
Excellent rule.
No
Can I speak
peeping.
to that?
Sure.
When I walk home, I pass by an apartment building that's right against the sidewalk. If I look to the left, I can look through windows and see what's inside. I'm on the sidewalk, so this does not apply.
I think the keywords here are intention.
Yeah, so Eric, you can't, if you stood there and looked in for a long period of time, you might be peeping. But if you just glance in and walking like we all do, then you're fine.
Just checking. Thank you.
I'm not sure if there's a hard and fast rule that would apply to this. There may be particularly on the criminal side, but is terms of whether it's a number of seconds or something along those lines. I would imagine that would probably be somewhat applicable if there is. Otherwise, I imagine it would be a reasonable standard. And I'm not sure what that would be, but it would probably be up to the administrative court or whomever is actually adjudicating an issue along those lines.
It's like porn, you know it when you see it, you know peeping when you see it. So it's not very clearly defined as a former prosecutor, but it's just, you kind of know when someone's crossing the line. That's as good as we can get.
And I think the key word again is intention.
Mhm.
Trash collection. This is one that has become an issue in terms of enforcement. Trash collection cannot happen after 9 or before 6 in a residential district. It is permitted at all hours in the non-residential districts. I know in practice, this can present issues for people who live near the industrial districts because you'll hear the trucks, especially when they're backing up and so forth. It can be fairly loud, but this is the way that this bylaw is currently defined. I'm not sure that we want to restrict trash collection for any other areas. But again, this is an issue, especially with the increase of mixed use housing. This is one that may come up over time. And Eric, to your point, again, it's offensive substances. How that's defined is kind of in the eye of the beholder. (154.5). This is one that does come up in practice fairly regularly. Door-to-door solicitors and canvassers. These are people who come by and try to sell things. I've actually most recently seen people trying to sell everything from magazines to cable service, internet service, things along those lines. And the purpose of this is very simple. It's to make sure that anyone who is going door to door gets vetted by the police. With notable exceptions for things like people who are selling Girl Scout cookies. So if you've got kids who are selling Girl Scout cookies, you've got people who are newspaper carriers, they don't need to have that registration. There's also an exception for religious purposes, and that's one that's kind of required. So anyone from the town, and again, students who solicit for shoveling of snow, does require they be a student, neighborhood youth, and similar services. So in other words, if someone is going ahead and doing lawn cutting and other local things, they're not considered to be soliciting. So if you find that someone has put a flyer in your door and they're going door to door because it's a child who's trying to, earn a few dollars doing lawn cutting, things along those lines, that's permissible. However, if they're doing it for a commercial purpose, different applies. Shall not apply for religious, charitable, or political purposes. While many of us would probably prefer to get rid of this section so that we don't have to answer to people who are coming for religious, charitable, or political purposes, that, as I've been told, would be problematic just due to First Amendment and First Amendment issues related to it. So that's the real reason that number 4 is in here. People have the ability to use the public way to have to make their opinion known. The key here is registration is required. They have to have a certificate of registration, the application components for that registration. In other words, if you see someone going by and they don't actually have a certificate, you can recommend, and I've done this with people, recommend that they go to the police department to actually get their registration. The purpose of this is so that the police can do a quick background check, and anyone who's convicted of a commission of a felony, state or federal, within 5 years, is automatically exempted. Anyone who, if their conviction was longer than that, is permitted. And if people are wondering why, I have been told by others, and you may have additional thoughts on this. It's a way so that people who may have had older felonies that are now released have the ability to potentially earn money and have a job and do something productive. It's may not be a job that they necessarily want, but they could actually legally do after they've paid their penalties and so forth back. The applications are acted upon within 5 days. This is intentional to make sure that we don't have people that put in an application and police sit on them. That's the purpose behind it. They'll issue the registration, and this is the piece that people should be aware of. They must carry it upon their person at all times while soliciting, and they must display it to whenever asked by a police officer or any person solicited. So if someone comes trying to sell you on, any of the cable services, you can ask them, do they have a certificate from the police? And they have to show it to you. That certificate will actually be like an ID card. It'll have their photo. It'll have information from the police itself. No one shall practice deceptive practices. Any canvasser shall not go if someone has a notice posted stating no solicitors are welcome. So if someone has a solicitors prohibited sign, they're not permitted to go there. Any questions? Fine is up to $300. Also, for peace and good order, another one that does come up from time to time is construction hours and noise limits. This is one that several places can have exceptions to this. These exceptions, I don't think, are well understood by many of our neighbors. but the purpose of construction is construction, reconstruction, alteration, repair, demolition, and or removal. It can only happen between 7 a.m., 7 p.m., Monday through Saturday. Sunday, no construction is permitted, unless they're one of the 3 exemptions. The Wakefield DPW and the MGLD has the ability to do any construction anytime that they need. This explicitly permits them to do 2 types of construction. One is emergency repairs, especially when there's things like water main breaks or repairs because they need to, especially the MGLD, needs to cut down a tree or they need to repair a road, something along those lines. Or they're doing nighttime things like nighttime paving because it's the most efficient time, the best time, the least disruptive. They have the ability to do it. On or in connection with a detached single-family home or structure, as long as it's not the construction of a new subdivision. In other words, if a person is doing work on their home, they can do work on any day, including Sunday. If it's a multi-family home, that's different because you now have multiple families impacted. And then third is very, very interesting exception by any person or connection with their own property. So in other words, if a person lives there, even in a multi-family home, if it's owner occupied, they can do repairs anytime they wish. For those of you who have to do your own repairs and we're hoping that you now had an excuse to watch football on Sundays, I'm sorry, if it's your own home, you can do repairs on Sundays. There goes my excuse. Okay, permits for this are granted by the DPW. If there is noise, and this actually has been an issue recently with the demolition that actually went at the head of the lake, this became an issue where there was unreasonable noise as defined by residents. Noise shall be deemed unreasonable if it interferes with the normal and usual activities in the affected area. And it can be reduced. And so the idea being that you can't have pounding for the sake of pounding. Anyone who's getting a building permit is supposed to get a copy of the bylaw. Bill, do you know if it's actually done? You're on mute at the moment.
I'd rather just stay on mute. There we go. No, I'm not in the department, so I don't know if they hand that stuff out. I'm assuming they do. I mean, they hand out a ton of stuff. They have like a rack of things they hand out, so we can confirm if you'd like.
It's something that if you can confirm informally, we'll go under the assumption for the purposes of this meeting that it's being done. But if it's not, if you can remind them that it is in there.
Will do.
And then the police department is the enforcer of this because it's potentially contentious issue. The fines on this are actually specified in this bylaw: $50 for first violation, $100 for second, third for $100. Each day or portion shall constitute a separate offense, so that way if there is someone who has a ongoing construction, it will be multiple offenses. Any questions on this? The piece that we may want to look at is the enforcement, is if we think that these fines should be raised to be consistent with others, or if since this is not something that I'm aware of that's been used regularly, if $50 is kind of enough for someone to realize, okay, it's not a problem. If it's ongoing, where it'll be $300 by the third day, $300 each day, that becomes pretty significant.
I guess it would fall under the hours. Was that section C? What I'm wondering is if there should be different parameters near a school zone. This has come up with Dolbear recently with the diesel gas station and some of the other construction happening around there. A lot of parents have mentioned this. There was one day actually where sidewalks were blocked, interfering with students and parents being able to walk their kids to the school with there were no police flaggers present at the time, and it was just up to the school crossing guards to kind of manage that. And I'm wondering if for morning drop-off hours, at least there should be something in here, since it's interfered with kind of flow of dropping students off at the school.
It's a good question. Joe, do you know if that's something that would be addressed under a ZBA order of conditions? If for a project of that scale? Because this, I take it that in this particular chapter, it's really envisioning this exception, and these components are really targeting more individual projects, and something
Right.
along those lines would probably be in ZBA area.
Yeah, what project was this? Was it?
This was not the Noria, I'm assuming, right, at Lowell and.
Oh, yeah, I mean,
Yeah, so that typically, Joe, those are done through my right-of-way permit. So, because keep in mind the timing of the contractor doing it, all that stuff gets, coordinated after the ZBA process is done with my group. So
Yeah.
they have bonds, insurance, different types of pieces. When I drove through, there was a detail there, but that doesn't mean, obviously, there was a time when he wasn't. So,
I live right down the street. I've noticed a few times too. My son goes to school there, but
Right.
anytime I've seen them ripping up the street, they've had a detail. And I mean, if it becomes a problem, we usually, we sometimes bring it up at a meeting. And if the lawyer is present, we'll mention it to him to talk to his client
Yep.
about that, to remind him that, but
yeah, and we have all the contacts for the folks that are out there. So usually the complaints will come towards Public Works and we'll address it.
Good questions. Kevin, does that address the question?
Yeah, yep.
Okay, continuing on, 154.7, added in 2009. Public consumption of marijuana, and there's an interesting spelling that I've always noted, different than how some people spell it, but marijuana, or basically cannabis. No person shall smoke, ingest, or otherwise use marijuana or the tetrahydrocanol cannabinol while on the public way. What makes this particularly interesting is that it is no longer a criminal offense in the Commonwealth, but it can be a civil offense if a person is doing something such as vaping while on a public way, including in a car, because they are technically on a public way. So if you see someone vaping, that is technically a violation of this section. Police department is responsible for the violations. The violation for every offense is $300.
Is there any reason, going back to the spelling? It's silly that we're spelling it differently than the state of Massachusetts spells it in its enforcement. Putting a J where the H should be, or where the H is.
I know that was the way that it was initially created. We'll have to potentially ask Tom if he comes on.
Yeah, I mean, I would spell it consistently with how the state spells it, but that's a tiny little point.
But not an insignificant one. Other thoughts on this? One thing I do want to mention is, since this was created in 2009, and since then, obviously, there's been the decriminalization. Do we need to actually still have the prohibition where we're prohibiting marijuana, but we're not prohibiting things such as cigarettes? And I'm not advocating one way or another. I'm just saying that there is a difference here between how we're treating marijuana from cigarettes and alcohol. And again, alcohol, you're allowed to actually, some alcohol is permitted with a permit on public areas, because permits can be granted. But and cigarettes are permitted, but in this case, marijuana is treated differently. Where again, it used to be considered to be a a banned product. I'm just trying to figure out the rationale for continuing with it. I don't have a problem with it. It's just an issue I'm just raising because I know that for some people they do regularly actually vape. In addition, should there be a carve out for medical use?
I think the key for me is the public consumption. So, you know, you can medically use all you want on your own property. You can drink on your own property. You can't drink on public property unless there's a permit given. No one's asked for a permit to smoke marijuana. Would be interesting. To have it on, like, you know, if there's a certain, I don't know, I can't imagine how that looks, but I think I am a fan of keeping this. I don't know that I want everyone to start smoking weed on the streets of Wakefield, even though it's not against the law to do it other places.
Other thoughts?
No, I agree with Anne. I think the comparison to alcohol is relevant. I think, you know, we can't walk down the sidewalk drinking beers. We can't walk down the sidewalk smoking pot. I think that's a fair comparison.
See no further comment. Moving on. 154.8. An issue that was added in 2011. I believe, Ann, you were on the council for when this issue came up. This was added and I believe it's been enforced twice over the years. For abandoned vehicles, this is typically for places where there's a lot of vehicles that's abandoned. It's usually decrepit. And the purpose of this is that if someone has vehicles that are not used, and there is a specific exemption for people who have project cars, but if they've got multiple vehicles, then it allows the town council to sell or lease those vehicles and to go ahead and get rid of them. And this actually has been, I believe, twice over the years. I'm not aware whether fines actually had to get collected. I believe that in both cases, the town was able to find contractors to mitigate the cost of the removal.
I do think it's an important bylaw to have, to take care in the extreme problematic properties. It's certainly been done in a thoughtful, empathetic way when it's been done under this bylaw.
Eric, did you have a comment?
In the 1950s, when my brother was in high school, he bought 4 cars. He used one of them for spare parts. After he graduated and went to GE apprentice school, he got rid of those cars, but there was a period of a few years when he had cars, even before he had a license. And I think we want to encourage young mechanics, future people like that. I don't think we would have a bylaw to stop the Wright brothers from playing with airplanes. So I think there's a question of discretion. If he continued to do this for 5 or 10 years, that would be certainly a nuisance, but just for 3 or 4 years, I see just a question of discretion by the police officers.
Well, it's actually enforced by the town council as opposed to the police independently. And to your brother's interest, I think the exception, section K, may address that. And Eric, you may be able to speak to this. So the exceptions section in section 1, basically, if the vehicle is owned and persons in active duty, Section 2 is not a violation to maintain one fully restored and an operative, even if it is unregistered. So this may or may not apply, that given the time frame you were talking about, they may not have been deemed antique at that point. But this is basically saying, if again, a person has a project car, it's not registered, they're working on it, that's permitted. In addition, if they have operative but unregistered vehicles and they have a business that's associated with it, that's permitted. In other words, if they're doing repairs. If they're being repaired and the repair can be lawfully conducted on the lot, they can do it. If they are not actually being repaired is when it becomes a problem. So where your brother was repairing the vehicles over time, or swapping parts and so forth, actively working on them, I would think that this particular exception would apply in that case. If he didn't have more than one vehicle that he did not actually intend to repair, then it could be a problem. And again, one or more an operative to provide spare parts for others, provided that the references shall mean permitted activity. In other words, what your brother was doing was specifically accounted for.
Thank you.
So there's a situation where I think, without knowing knowing about your brother's situation, but knowing there are quite a few people who are car enthusiasts, this does have some measured language in it. And I think this was particularly done in a delicate way so that people could have project cars. They didn't get, in some cases, multiple. I have a neighbor who has quite a few project cars, and they come and go on a fairly regular basis. Again, they're not abandoned according to this. And I would not expect them to be deemed abandoned where they actually are repaired.
Okay.
Interestingly, in 154.9, note the spelling is different for marijuana establishments being forbidden. I think that this actually may be the justification, and to have the prior version spelling corrected. But again, I think we'll want to get guidance from Tom on that if he's able to rejoin. Marijuana establishments prohibited. I don't know whether this was done before the legalization. I don't know if this is actually even enforceable now. Given the various laws, I would tend to think that this particular section is no longer enforceable. We may want to see if it should be removed as a prohibition, because it would be zoning that I think would govern the permissible use or not.
Yeah, I think this is against the law. I think this statute, I think this section right here is not enforceable. The AG's office talked to that a few years ago. So yeah, I'd love Tom's input. I don't think you can whole across the board ban it.
And I believe Wakefield was actually among the very first test cases to get it approved before the ban, before the ban was overturned.
We were.
Okay, so we will defer that section as well. This brings us over to 154.10. Something that happened at 2017 town meeting after it was deferred at the 2015 or 2016 town meeting. Plastic ban, cutlery, stir, and drinking straw reduction. The purpose of this is to get rid of single-use plastic bags. And Wakefield was on the leading edge of this particular issue. It's now been adopted at a larger scale. And where there's now state requirements that require charges for paper bags, I don't see there being a problem with this particular componentry as it is written. It seems to still be fairly up to date. But heavier plastic bags are still permitted. the various establishments in town seem to be complying with this for the most part. One question that I will have for Tom, if he's able to join, is if the first offense is a warning, does it have to be documented? Otherwise, how will you know that you've actually had a first offense? Otherwise, it seems like every offense is going to be a warning over and over again. Again, I haven't seen this to be a problem for the food establishments. I know that there was initially some pushback on it. Any thoughts? Okay. So hopefully Tom will be able to join us. We'll revisit this component as well. So what I have on my list is to check the spelling of marijuana, to check the enforceability and appropriateness of 154.9, or if 154.9 should potentially be revoked and replaced with either a renumbered 154.10 or possibly just put in as a reserved item. And again, what has to be done for enforcement of 154.10 of the actual warning. Any questions or thoughts? Other items? Going once, going twice? Everyone in peace and good order, except for Tom, who may have peace but is not able to join us in good order. Okay, sewers, which is maybe where some people think that certain politicians and so forth should go, but that's not what this is about. This is really about where sewers should be and what the requirements are for them. So notwithstanding bad humor, the purpose of this really is to make sure that the sewers are known. Sewers are important for the town, also to understand that we don't want to have sewers in places that are not documented. It certainly can cause issues for dig safe if someone does digging and digs into a sewer that was unknown. So really anything that's owned by the town, Director of Public Works is responsible for. Bill, I believe this area falls within your general area of componentry for the sewers.
Yes,
Is
sure
that correct?
does. Yep, correct.
Okay. Is the description of sewers that I gave reasonable?
Yep, for the most part. Yeah. I mean, I think a lot of this is really about the betterment process, to be honest with you.
Right.
And how to expand the sewer system. But I think realistically, it's probably more legacy stuff because this would have been probably back in the day when they were trying to sewer the whole town. But either way, let's go at it.
Okay. So that brings us to 165.2. Again, a lot of this language is relatively old. This was adopted in 2003 as part of adding in sewers themselves. It allows the town to have charges when there are expansions, particularly for subdivisions. Sewer units, again, where the town is a part of the MWRA and there's charges for sewage based upon our water consumption. Understanding how the different properties are managed becomes very significant. That's part of the reason my understanding as to why we have the sewer unit designation. If there are any betterment payments shall be apportioned over no more than 20 years. If this, I think, applies when there is an improvement on a private way predominantly that is done by the town. Is that accurate, Bill?
Back when you were expanding sewers for your whole entire town, you would do betterments on those streets as well. So it would be public ways too back when the town was expanding their sewer system.
Okay. But I think lately it's just been if there's still a private way and they need an expansion or a change to the sewer system, it allows them to have that repair or otherwise
Yep.
to be spread out for those owners over 20 years.
Yeah, they can request a betterment to go through, and we have a whole process for that. But yep. I think we're in the home stretch on this one too, because we only got about 20, maybe 20 septic systems, if that.
Okay. And abatements, the town council have the ability to abate the assessment on each owner's property if the property is unbuildable or already connected. So in other words, if there's an issue and it doesn't apply, it allows the town council to waive that assessment if they would otherwise get charged. Questions, thoughts? Sewers? Moving to storm drains. A lot of sections here, although this tends to go really quick. This is largely managed by the DPW itself.
So first section basically is to prohibit folks from putting anything other than stormwater into a storm drain. Article 2 is for our NIPD's program, and it requires us to have a review of land disturbance and erosion controls. That's come up recently in some other discussions for some other projects. We have some housekeeping that needs to be done. That's probably the main reason I'm on the meeting today. So, I didn't realize that we were going to be talking about this until today. So I can have some revisions planned for the next meeting if that works for folks.
Yep.
A lot of the other stuff that goes within it is a little repetitive and a little redundant. And then also there's just the mechanisms on how it comes into my office is clunky. So we're looking at to make a few tweaks to this just to make it kind of consistent with how we operate today.
Okay, that would be helpful if we can get guidance on this, because this particular chapter, again, it's a very long chapter and it's
Yes.
it's very heavy reading for anyone who tried to go through it. It's just lots of definitions and it gets into a lot of detail. So if we can get specific recommendations, that would be very helpful.
Sure.
The other thing I was going to add, Dan, if I could for a second, this is Bob,
Sure.
is back in November 2018, there were changes made to this section more than just changing the name to town council from board of selectmen. There were substantive changes made in Articles 23 and for the sewers, and Article 24, warrant Article 24 for the storm drain system from the November 2018 town meeting. So I remember we scrubbed through this because you're right, it's a hard reading. But there were, Public Works came in with a lot of substantive changes back then. Not just changing the name from selectmen to town council. We also grappled with that disorderly conduct back in 2018.
Yes,
right?
we did.
What we noticed is that a lot of municipalities in Massachusetts still have disorderly conduct on in their bylaws or in their city ordinances. A lot of that predates when the MGL was passed on disorderly conduct. And I think the decision then was to just keep it because the definition is the same as the Massachusetts general statute. It's just that we have to look at the MGL to make sure that our disorderly conduct definition changes appropriately if the Commonwealth changes its definition. That's all. But we grappled with a lot of these things back in 2017 to 2019.
Thank you, Bob. Yes, I do remember lots of discussions. We also had a lot of discussions about news racks just for the sake of having discussions. We had one member back then who loved the concept of news racks, even though there were only a couple in the town. Okay, other feedback, otherwise we're going to defer this particular chapter. That brings us to the final chapter of the existing components. And the good news is we've actually visited a lot of this before. There's 175 streets and sidewalks. We've visited section 3, snow and ice, several times. The purpose of this is just to go over some of these components. My recommendation, given the hour, is that we defer this particular section to the next meeting. And if people can look at this really talks about what you're permitted to do and prohibited from doing on the actual streets and sidewalks. We've obviously talked about snow and ice, and we haven't recommended any changes to that so far. But Articles 1, 2, and 4 in particular talks about, okay, what should happen on that. It also talks about how to handle the private ways. So if you see a street, then it says private way, the town has the ability to repair it, and it's a matter of how is that assessment done. So that's the purpose of this particular chapter, but I recommend that we defer this to the next meeting. And part of it is there are some pieces of it that are parallel and similar, particularly in Article 4, to some of the sewer and water componentry. Any questions so far? So with that, we have new items. There are 3 items that we haven't had a meeting that's discussed a lot of the different issues that have come up in town that would be general bylaw related. We haven't had an issue discussing general bylaws in a while. So there are a few different things that have come up fairly recently, and just want to bring those to the group's attention. I don't expect that we'll necessarily make any particular decisions at tonight's meeting. So the first one is a follow-on to one of the items that we discussed when we first started in the bylaw review committee, and that's what was chapter 155. This is actually the town meeting article that was submitted to the 2019 spring town meeting by the prior bylaw review committee to discuss vacant commercial buildings. The purpose of this, and this was not adopted by town meeting, it was approved by the bylaw review, it was not adopted by the town meeting, but the purpose is to address vacant storefronts, particularly in commercial areas, and to make it so that those spaces would have the ability to have visual improvements and structural improvements. As many of you may be aware, there was recently a fire in a abandoned property, and fortunately no one was injured, but those types of properties become actually a good example of where having vacancies that could potentially be improved, to think about for 4th of July and so forth, to have art or other uses of those properties could be a good use if the owner is not actually using it for an occupied use. So anything that is vacant, it would have the ability to do it. In addition, it makes it easier for the town to do periodic inspections, and that becomes a safety matter. So I sent a copy of this bylaw out to all of the members. It's also available. I'll make it available on the website for the committee itself. I recommend review it as it was last documented, and we'll discuss it more at a future meeting. This is modeled after a bylaw that has been in use in Arlington. So that's where the structure comes from. This was not going to be brand new to the Commonwealth, just new to Wakefield. And among the important components of this is a property that is vacant for a very long time. It can have the fees turned into a lien so that someone can't just sell the property to get out of the charges. In addition, if there's an issue such as, say a virus that shuts down businesses, not that any of us have seen that over the last several years, that we wish we could forget, but there is the ability to apply to the town council for a waiver. And the town council has historically shown a lot of deference to business owners and property owners upon request of things that are deemed reasonable, and also enforce bylaws where they don't deem it reasonable, as we were discussing earlier in tonight's meeting about things such as vehicles and so forth. That generated a fair amount of discussion for the town council before they enforced and eventually did remove the abandoned vehicles. I envision something very similar for this. So if people can take a look at this bylaw, I'd like to see to discuss it at the next meeting in more depth. And for those of you who have particular connection to businesses and real estate, and for that, I'm thinking of Mr. McGrail, who I know is joining us. This becomes something that could be, again, of benefit to businesses and real estate if the nearby properties actually have a better visual appeal. So I think that it actually becomes a better componentry, and for property owners who really are just sitting on the properties and not taking action, it'll force a more involvement with the town for those commercial properties themselves. So again, feedback is welcome, and this is what I have here, and what I will have added to the website is exactly what was recommended and submitted for the warrant in 2019.
Dan, I'm
Yep.
curious, you mentioned that it was approved by the bylaw review committee in 2019, but not approved by the town. Are you either today or next time when we discuss this, able to share some of the reasons why it wasn't approved?
I can't speak for all of town meeting. My recollection is that there was resistance based upon really three components that were causing resistance. One was lack of knowledge that it was being discussed, even though it was discussed for actually over a year before the language was finalized. So that the marketing piece was one componentry. The second part of it is that there was a nervousness about implementing it where it had just been implemented in Arlington, and it was unsure whether it would be successful in Arlington, whether it would be used well. And so it was kind of a wait and see desire by quite a few people. And that was another sentiment that was definitely expressed. The third was a resistance to anything that would potentially be deemed a new fee or tax on property owners, regardless of the use, or in this case, lack of use of the property. Now, I found that to be a rather interesting conundrum, because if a property is not used, then particularly commercial properties, then it is not uncommon for those property owners to request an abatement or reduction in the amount of assessments for the taxes, because the value of the use of the property gets reduced by the fact that it's not actually being rented out. So those are the three reasons that I recall. For others who were at that town meeting of other recollections, by all means, please feel free to contribute.
There was also a little bit of my property, my business, and don't tell me to make it look pretty just because you want it to look pretty. There was a little vein of that going through, but I think that was very much related to Dan's first point, that people didn't understand what this was about. I think our chances of passing this are greater now because we have more vacancies, and we've actually seen what vacancies can do to our downtown, and what that looks like and feels like. So I think with some good education, Dan, I think this is, and looking at the language, and we'll review it, but I think it might land on folks differently this time.
It's helpful to hear that background, just especially as we all go to review this, to keep that in mind, as those were the concerns. It seems like at least two of three of them are addressable, if not by the text, the language that are proposed, but in terms of the process that we would use moving forward.
Yeah, I also just I mean, and I did rewatch that section of the town meeting. It's on YouTube, so you know, I think maybe ahead of the next meeting, it's probably good to. I think it's like 30 minutes of debate, and I think there are some not there's probably some process and issues about the specific wording in this bylaw. You know, besides some philosophical issues or whatnot, I think there's some issues about how some of the actual wording would apply in real life as well.
Other thoughts? Mr. McGrail, if you've got any thoughts on this or contributions, because I know you've represented a lot of commercial property owners, certainly interested in your opinions as well.
Yeah, I have to read it. I don't have an opinion on it either way at this point, to be honest with you.
Okay.
I vaguely remember at a town meeting, I think what Ann said is true. I think that was some of the reluctance with people telling other people what to do with their property. I do think there was a little bit of tone of that, but you know, sometimes time goes by and people change their thoughts. So I'm open to it. I need to read it in more detail.
Appreciate that. So that brings us to the last issue. I'm going to give people a trigger warning in advance because this next section, the last issue that I listed here, it's intentionally last because this is honestly hard to see. I'm not sure for those of you who may have been following social media lately. It was actually last month, there was a red-tailed hawk, sometimes referred to as the Wakefield hawk, that was found to be, it was a juvenile, first year fledgling, that was found in the west side, and it was very, very sick. It was actually in the process of dying. It was captured. 2 weeks of every 2 hours of restoration, it was able to be saved, and it was released last week. So why was it sick? It was sick because it had rodenticide. Rodenticide causes a lot of really, really bad things to happen. We have a lot of things that need to be done for rodent control. One of the, and I'm going to share some pictures taken by a fellow resident of another bird that actually succumbed to rodenticide that frequented Wakefield a lot. Rodenticide, specifically what are called SGARs or second generation anticoagulants, is something that is a poison, sometimes referred to as rat poison, that is used regularly in the town and can be found in the town, including in violation of their own material safety data sheets. So around all of our larger schools, you will find bait traps. These contain a substance inside that's not supposed to be used for more than 3 weeks. If there is water in the environment, consider what's going on outside. It is so dangerous that anyone who is in contact with that water, their shoes are supposed to be destroyed. And any pets are likely to die. It is extraordinarily dangerous chemicals because what it does is it causes the prevention of vitamin K, and therefore, without vitamin K, blood does not clot. Animals bleed out from the inside. With that, I'm going to share what happened to, and again, trigger warning. I apologize in advance. These are photos that were shared, that are specifically shared under permission for this presentation. By what happened to MK. MK is an eagle that flew around Wakefield for many, many years. MK had a mate. You may recognize the photographer. There's Karen McNamara. She lives over on Main Street. That's MK and its mate. They lived nearby. They had a great family. Ultimately, at some point, she had eaten something that had a rat poison in it, and she succumbed. And this is just hard to see. This is how she was found. And yes, this is an adult bald eagle. There is no way to say that this should be done. Current law allows for a bylaw to be put into effect that would prohibit the use of these types of rodenticides on public property. What people do on private property is not currently permitted. There's a home rule petition that was started also by Arlington in this case to request the legislature to allow through zoning to ban these types of rodenticides on private property. But on public property, the town so far has not taken action on this particular issue. We do have rodenticides and the rodenticide similar to what killed MK, the rodenticide similar to what caused the red-tailed hawk, again, to be extremely sick. And we know that there was a Cooper's hawk that also succumbed recently as well. And so this is a real issue. There are other means to manage rodents. There are other means that are non-lethal as well as lethal, things such as electric traps and so forth. Arlington has a program in place, including a bylaw. I did ask our town administrator Mayo to get a copy of that bylaw so that we could review it at a future meeting. And it's something I just want to present is a very real issue, as we have a lot of protected wildlife. I know that many of us have seen, especially in late summer, we've seen and heard the hawks, seen some of the eagles that have been hanging around. Almost all of them have had young that have died due to rodenticide, and that is documented. So it's really hard to see, and one action we can take is to at least eliminate the public use of rodenticide and potentially sign on to the request for home rule petition. That's a separate issue that I don't view as a part of bylaw review, but having a bylaw is something that's certainly something we may want to think about. So again, just wanted to present that, and to have something as beautiful as a bald eagle, go through this process. We really do want to, support things. And when you think about, we have the ability to have beautiful, truly beautiful wildlife, and we can save it without having the risk of having, unmitigated rodent control. There is a cost difference. The other forms of rodent control do cost more. But what is our priorities? Is money more important than animals' lives that are using our environment? Just want to throw that out there. I did, in all fairness, bring this up to the town council in the spring. No issue has been taken by the town council on this issue. So it's something that administratively was requested. The contents of the bait boxes was verified, and it just, without further action, I've had several residents request that we take action of some sort, so I'm bringing it here as well. Thoughts, comments?
I'm in support of us looking at this. I'd like to see the Arlington bylaw also. I'm curious about the cost differential. Just because I think that's important to know as well, but I think it's certainly worthy for us to take a look at.
And I haven't seen, I know that the warrant article for Arlington is available that has some of the language, but not the final language. So that's why I've requested Steve get the final language from Arlington for our review. Their bylaw goes into effect January 1st, 2024, just in terms of timing. That part was built into the bylaw. So in terms of effectiveness and so forth, we're obviously not going to have anything for the November town meeting, but it's something that by the time we get this approved, it'll be in effect. Other comments, thoughts? You can truly say that if you know, what you're doing is for the birds, yes, it is, but it's for more than that. This affects birds, it affects foxes, it affects lots of wildlife that either eats, feeds, or is a part of the ecosystem. And again, the town, it has a lot of these bait boxes around public buildings. So while this type of bylaw wouldn't affect the private property at this time, it's at least a start, and it'd be a statement of Wakefield values. So that's where I'm bringing it up. There are groups that are definitely taking action. I think we will. It's better for us to be on the leading edge of this than being on the back side of it. That brings us to item 6 on the agenda, upcoming dates. Next meeting is scheduled for October 2nd. I was notified earlier today that coincidentally, due to the Indigenous Peoples Day on Monday, October 9th, that apparently the town council has decided to change their meeting schedule to be October 2nd and October 16th, which are the same days as our planned meetings for October. So, and in looking at the calendar, we're going to have some other months that are difficult coming in the middle of winter. So we'll want to figure out what we want to do for options here. Just wanted to get people to think about their schedule. We can, as of now, we currently have October 2nd as our normal first Monday, but I know that if it's the same day as a town meeting, we are unlikely to get Attorney Mullen for that. And at this time, we would probably want his assistance for going over general bylaws while we're still waiting for Attorney Bobrowski's waivers to get put into place and approved. So my thinking is to potentially move the October 2nd meeting to potentially October 3rd, which would be a Tuesday. Wasn't sure of people's thoughts on that or availability.
That works for me. Yeah.
Works for me.
Prefer to keep it on Mondays as much as possible, but I could do that Tuesday.
I have a similar preference, Tim, as well. I prefer first and third Mondays. I just know that we're having difficulty, at least for this next meeting in October, and January is the next month I know is going to be very difficult because both the first and third Monday happen to both be holidays.
Will the next meeting be on a Tuesday, also the 17th? You got to do that one also like that.
So the second meeting for October 16th, I'd prefer to discuss that more if we have a meeting on October 3rd. I'd prefer to discuss it then, because if we have approvals for the exceptions to begin working again with Attorney Bobrowski, then I think we keep October 16th, the Monday meeting. If we don't have the approval by then we may want to move that one off by a day as well. Or move it to possibly, the following Monday, which would be the 23rd. But I think we're best off discussing that on the 2nd after which will be after the town council is able to take their action as may be necessary. Other thoughts, other availability?
That works for me, moving it to Tuesday.
Eric?
I'm the
Lucy?
most flexible person there is.
Dan, I had emailed you that I wasn't gonna be able to make that Monday, and I'm traveling that Tuesday, so I'm not positive I can make it, but I wasn't gonna be able to make the Monday anyhow. So it sounds like you have quorum here.
Correct. And just because you're traveling, no excuses. you just kidding. Lucy. Wait, is Tuesday? Okay. So with that, we will move that to October 3rd. In anticipation of that, I will certainly send out a note just as a reminder in advance of that. if anyone wants more information about about the rodenticide issues or other pieces, I'm happy to put you in contact with the various groups. It was the Cape Ann Wildlife is the one that actually that was able to nurse back the red-tailed hawk, and so much thanks to them for their work. It cost hundreds of hours, hundreds of dollars to actually nurse that bird back to health, and they had to release it locally. So we're hoping that it does not get further poisoning. So this is not a local issue, but it's hyper local, and that we have to try and take action one community at a time to really help it minimize dangers from some of these chemicals. The idea for people who've actually seen the birds bleed out, it's really, really hard to watch because they literally bleed out through all of their organs. Not something that we'd want to do. Okay. Otherwise, holidays coming up. We've got Indigenous Peoples Day, sometimes referred to as Columbus Day, formerly known there on Monday, October 9th. Hope that everyone is able to enjoy that weekend as well. In addition, we've got town meeting that was just announced for being Saturday, November 18th. As a town official, we are each required to be there without good cause. If you have a reason why you cannot be there, please email me with the reason that will be deemed good cause, in case someone should ask, okay, why is members of the bylaw review committee not there? At this time, we do not have any articles that are ready for submission for this particular town meeting. I expect that we're likely to have a series of articles for either the May town meeting or next November.
Is that at the high school, or
I believe it's at the Galvin.
at the Galvin?
Any questions? Other items? Going once, going twice. Okay, we'll take a motion for adjournment. First, I want to thank Ann for taking the minutes for this meeting. Catherine taking minutes at prior meetings, much appreciated. With that, do we have a desire for a motion to adjourn?
Motion to adjourn.
Joe has made the motion to adjourn. Let's see, who have we not heard from? Tim or Lucy or Eric?
I second it.
Tim seconds it. Lucy, Eric, Kevin, any of you want to give a third or fourth?
Yeah.
Third.
Okay, Lucy's third, Eric is fourthing it. Kevin, do you want to fifth it?
Why not? Fifth.
Okay, so we have a motion and four overt supporters of it. Any debate on the motion? With that, we will take votes as you are on my screen. Joe,
Yes.
Kevin,
Yes.
Ann,
Yes.
Eric,
Yes.
Tim,
Yes.
Lucy,
Yes.
Catherine,
Yes.
and I vote in the affirmative. We have unanimous vote. 8:50, the meeting is adjourned. Thank you, everyone. We'll see you in a couple of weeks on Tuesday, October 3rd.
Thank you.